intro as well. Hi. Oh my God. Sorry.
Yeah, I mean, I'll lead you.
I just didn't know that we were going to go live that moment.
Well, now you do. So, yeah, it's all yours.
All right. So I'm here tonight with Shane Rode, and we're going to be talking again about some sort of recent legal developments. How are you going, Shane?
Very well, mate. Long day today, which is, it's always good when you have long days for your bank account when, these clients eventually pay you. But right now I'm just tired. And actually the last thing I feel like doing is a legal tirade, so to speak. But I always warm into it once we get going.
Yeah, no, I feel that. I've been trying to carpet a house today, which is a bit of a change of pace. Hasn't been going super well, but probably a lesson in terms of sticking to what you know.
Would you describe yourself as a carpetbagger?
Can't answer that one.
I explained to Liam the other day what a carpetbagger was, and he looked it up as his want, and it's got quite an unusual meaning, which obviously developed dialectically over time. But it was originally to do with people joining mercantile societies, would you believe, for the purpose of influencing them outside of the normal kind of ambit of their authority or influence. It's quite a good term though, carpetbagger. I quite like it.
No, it is good. So yeah, the case that we'll talk about tonight is Southern Response and Dodds. So this is a recent Court of Appeal decision that came out early last week. So it's one of the various Christchurch earthquake litigations with respect to insurance, and it concerns misrepresentation under the Contract Commercial Law Act. So I might just quickly go through, what the relevant facts were, and what the court found, and then we can maybe have a bit of a chat around it. So basically, the Dodds had a house. It was damaged beyond repair in the earthquake. And so they went to their insurer, which was AMI at the time. Later, the name was changed to Southern Response. And they contracted a company called Arrow International Limited to do a repair and rebuild analysis, which they call a DRA, to work out what the costs of rebuilding the house would be. So they had two versions of this. One was a full report that included all of the sort of intangible elements of the rebuild, like a contingency cost, professional fees, all of that. And then the other one was just the actual costs of building. And the report that they gave to the Dodds was the abridged report that didn't have all of those other costs in it. And that had a value of $895K. And they said to them, you can either we'll spend this much money to rebuild a house, or you can go and buy a house for an amount up to that amount. And they entered into a settlement agreement with Southern Response based on that figure. And then afterwards, there was this court case called Avonside Holdings. That's what it's abbreviated to. And it concerned whether or not that it was correct for Southern Response in another matter to limit how much they could give someone to go and buy a house to the abridged amount. So the policy, they had this idea that the amount that you should be like it's kind of quite convoluted logic on their part. Basically, what they said is when you go out and buy a house, you don't actually incur, professional fees or contingency costs. So that shouldn't be included in what we value as the amount you can go out and spend, which, just parenthetically is kind of odd to me, because when you go and buy a house, you don't incur the costs of building either. The whole point is that when you buy a house, the value of that house reflects all of the costs that go towards, having that house built, not just the sort of physical elements of that process.
That was one thing. One thing from a conceptual point I thought was odd when I read the decision just earlier as well, is that the whole concept is notional. To say that the only part of it is not included because it's notional seemed to me artificial distinction. But I'll let you continue on.
I agree. I thought it was a very weird kind of distinction to draw, and so the Court of Appeal agreed, and the Supreme Court, and they said that the amount should be this full amount. But the case itself came to the Dodds' attention, and they realized that, this distinction existed. And so, they put in an information request, and they came to learn that Southern Response had this other document. I think under the abridged one, the estimate for rebuilding was about 800K. Under the full one, it was more like $1 million. So they claimed that they had, the position had been misrepresented to them, and the representations made by Southern Response were false. And so they sued for the difference, which was about 200K. Now, the Court of Appeal found in their favour. They upheld the High Court decision, which was also in their favour. And they found 3 relevant misrepresentations that were made. And one of them was that the amount in the abridged DRA represented Southern Response's full estimate of the rebuild cost. The other was that the estimate of the cost of rebuilding the house on the present site was the amount set out in the abridged DRA. And just on that, what was relevant was that, as well as the DRA and the policy, there were quite a few sort of surrounding documents, letters from Southern Response to the Dodds. And one of them said, the maximum amount for taking a go out and buy a house option is this amount, which was the amount in the DRA. And the letter said at the same time, this is the amount it would have cost us to rebuild your house on the present site, which wasn't the case. It would have cost them more. So those 2 misrepresentations would have been enough. But what makes this case interesting is that the Court of Appeal considered that there was a 3rd misrepresentation, which was the fact that the policy entitlement under their insurance policy was to buy a house for a value up to the abridged DRA. In other words, the legal position that the amount that they could get is limited, that notional distinction is valid. Like that position they thought was a misrepresentation in and of itself. And that's a lot more interesting because there's a common law distinction between representations of fact and representations of opinion or representations of law. And ordinarily, at least in the past, it's not been the case that you can get misrepresentation, at least in this context, through a misrepresentation of the law. But after this case, that position's a lot less clear. So that's sort of an outline of the case and what was found. So Shane, do you have any sort of views to kick off a discussion of that?
Yeah, so thanks. That was an awesome summation, very succinct and clear. So I'm just bringing up on my phone. What I thought was really interesting was that I couldn't help feel that this insurance company, AMI, was penalized by the court for what seemed to be, whichever way you spin it, dishonest behavior. And I can't help feeling that possibly spewed into, for want of a more eloquent term, a decision whereby there was findings of multiple misrepresentation. Like you said, that the fact that it was the only report, the fact that it was the estimate of the cost of the rebuild, and also more crucially and more interestingly, as you say, that the opinion of the interpretation of the insurance company and I'm assuming their lawyers was that wording was the actual entitlement. It seems to open up this decision as a precedent for a lot of more interesting decisions. But before we go down that kind of rabbit warren, so to speak, I just wanted to talk about the contrasting decision in Prattley Enterprises Limited versus Vero Insurance Limited, which was in paragraph 134 of the judgment. We can put the judgment in the comment section afterwards. In this case, it was an claim for an indemnity insurance cover on a commercial building, and there was the option for the insured, the building owner, to either invoke a market value appraisal of the building or an indemnity depreciated replacement cost. They settled for the market value and then later tried to argue that they were misled and that it really should have been on the depreciated recoverable value. Now, the court actually said, and it stopped short of commending the insurer, but it did actually say that there was a full, open and frank disclosure and evidence of communication between the insured and the insurer. And accordingly, the court did not found in favor of the insurer by saying essentially that while there was no doubt that the insurer suffered some sort of adverse, their position was made worse by the election, so to speak, to insure it one of the two. There was no finding of misrepresentation because of the conduct or behaviour of the insured in this instance. Now, contrast that to this case where you have mum and dad investor. Admittedly, there was a conveyancing solicitor involved, but as the court said, they're not a litigation slash forensic lawyer trying to look into with the benefit of experts on call to make sense of it. They just relied on the fact that with the additional paragraphs of the insurer to say this is really the best estimate or the real estimate, I should say, of what it would have cost to build the house, which is the reference point for the amount they got paid out for the new house. Now, that's quite a different situation, and it really feels like by withholding that information and being relatively steadfast in their pronouncement, that was actually the proper basis, that they've been caught short here. What do you think about all that?
Yeah, I agree. I think, not to say that this is necessarily a bad case, but that adage that hard cases make bad law, came to mind when I initially read it. It seemed like one would be quite sympathetic towards the position that Dodds found themselves in when they, everything that they'd received from their insurer, and sure, an insurer is a counterparty, but in a consumer context, they're a party you tend to be you think they're reputable generally and invest some trust and repose some faith in what they tell you. And, for them to learn that what they'd received was not actually a reflection of what it would cost to rebuild their house, I think the court would very much have wanted to find in their favour. So that's in the background. But the thing that I admit puzzles me somewhat is that the court could and indeed did find for the Dodds on multiple fronts. So the two representations of fact that happened to be wrong, they would have been enough. And even if they hadn't been enough, there was also a Fair Trading Act claim. And in the context of the FTA, the statute's very unambiguous that clauses in a contract can constitute representations for the purposes of the FTA. So they could have come to the decision they wanted to come to without doing anything on this subject of whether a representation of law is capable of being a misrepresentation. And yet they decided to go there. So, they did so mindful of the fact that in the UK, the law has gone a long way towards eroding that distinction. And so maybe there's policy arguments behind that that persuaded them that that's a good direction to move in, and this was an opportunity to move in that direction. But I have to confess, like, to me, I'm not sure what those would be, because, as the lawyers for Southern Response pointed out, this proposition about what the insurance contract meant, it wasn't like a really tenuous, difficult one to entertain. The case where the legality of that position was determined went to the High Court, and Southern Response won in the High Court. So you've got a situation where Southern Response, or more likely their in-house or external counsel, came to a view about a legal proposition, and that view was sound enough that a High Court judge thought, okay, I buy that. And then the Court of Appeal decided that it didn't, and hence it became a misrepresentation.
Mm.
And it's also the case, if you have that sort of declaratory theory of law, like, until the Court of Appeal determined the matter, like, I can't see how it could be true or false.
Yeah. I thought that was an interesting point in the case of talking about, it's not correct on a principle basis that something is a misrepresentation just because a court later judges it to be so.
Mm.
Yeah. Do you think, I'm just sort of spitballing here and thinking out loud, do you think, though, that they wanted to pin parties in the position of the insurer, particularly when it's a commercial party versus like a private individual, for hiding behind behaviours or the assertion such as, well, they're qualified to look at it's their clauses, they draft them, and then to come out and just really dishonestly or purposefully misrepresent the real effect or the real meaning of a clause, to come out and say, well, and then and then to make the law so they can't hide behind that when they're very clearly misrepresenting what they really know to be the true meaning of the clause. Because that was quite egregious, the level of deceit, if you ask me, by them setting out what they're, to the extent that because they changed at some point, they provided the full report, the DRA, and then they decided to stop putting the full, obviously it was a commercial decision, and then they had some sort of pro forma wording around this may not represent the full amount because it may have these other parts in the office use part of the thing, right? So they knew full well what the mechanics of their contract was. So then to actually say, in our view, this clause represents, in our view, your position. I think the court has said, well, we want to move, like you said, with the UK decisions, to a position where parties cannot hide behind an obviously disingenuous interpretation of a contractual provision. Just want to move on a little bit and try and give the viewers a bit of practical relevance in terms of because this will sound like absolute mumbo jumbo to most of us. In fact, it was to me. I've got a brain ache from reading it. I don't know about you. But you said to me earlier today, Mike, or yesterday, that you had recent experience with a couple of cases where there've been alleged misrepresentation in the sale and purchase of businesses. Without going into too many specifics, could you sort of maybe just talk a little bit about the sort of the principles or the issues at play in those cases, and then we could maybe discuss how parties looking to contract or parties already under contract need to be mindful to not be found to have misrepresented themselves, bearing in mind that these parties need to get deals done as well.
Yeah. Okay. I mean, I see the litigation side of this, obviously, and as you said to me yesterday, in doing a lot of sale and purchase of business agreements, this would be an issue on the due diligence side of things and what information is provided to the prospective purchaser. So in the ones that I've been involved in, the first thing is that under the Contract and Commercial Law Act, when a misrepresentation has occurred, you can either look to get damages for any damage that's resulted from that, or you can try to cancel the contract. And cancellation of the contract has a slightly higher bar, because as well as showing that there was a misrepresentation and it induced you to enter into the contract, which you also have to do for damages, you then have to show that the representation was either essential to you, that is, if it hadn't been made, you wouldn't have entered into the contract, or that it substantially detrimented you. And why this sort of distinction, why this set of options is important, is because the advantage with cancellation is that immediately, it's very quantifiable what you can get out of taking that kind of case. Like, you've paid this money for a business. Usually people that come to us with these kind of cases are coming to us and saying, I bought this business, I paid all this money, it was made out to be a good business, it turns out it's a dog.
It turns out it's a dog.
It's often the turnover will be a lot less than what was represented. And at that point, like, we can say, if we assert cancellation here, that's quite an easy way to go, because you get all your money back. You're no worse off than you would have been had you not done it. But it's a much more difficult thing to achieve. If you just go for damages, and sometimes there are reasons to do that, like the case I'm doing at the moment, the turnover is down substantially, but there are certain elements of the business that the acquiring business has.
Just to weigh in there, if it was the Auckland District Law Society sale and purchase of business agreement, there's not a lot you can do there in terms of if there's a turnover warranty. It's quite sort of perverse, really. People think, when they sign these things, that's why obviously people like us exist. God forbid, is to, in theory anyway, to protect people, because you've got a turnover warranty that says the business did X amount of trade per week or month for the last 6 months or year or whatever. But there's nothing in there that warrants that trade will continue. All it says it's inaccurate. So, what are you trying to? I'm just trying to, because I don't know, I'm not a litigator myself. Are you trying to draw inferences from those warranties, and you're trying to bring in misrepresentation? So, for example, if there's an absolutely precipitous drop of revenue off a cliff the minute they take over, is that sort of?
That's exactly right, Shane. That is the difficulty, is that you're faced with a situation where someone's coming to you and they're saying, the turnover I'm receiving is much less than was warranted. And of course, anyone in business knows that not everybody manages a business as well as everybody else. And market conditions change, and there can be all sorts of reasons why someone's turnover isn't what the previous owners was.
Yeah.
And the fact that it was what it was at the time doesn't make any kind of representation about what it will be. And in fact, representations about future events can't be misrepresentations anyway, unless you believe them to be false at the time you made them. So what you're doing in that situation is you're going, okay, this is sort of prima facie evidence that there may be something nefarious going on here. Like, if you're talking about a really great disparity over a very short period of time, like, you're saying, how can this be explained other than with reference to the purchaser misrepresenting what the turnover actually was before the business was sold? But then you've got to somehow get enough certainty around that to warrant actually going to court. And that's where I was kind of going before in the conversation, is that at least with the cancellation option, like, you show that something was said to you that wasn't true. You show it led you into the contract. you show that that term was essential to you, that had you known it wasn't true, you wouldn't have done it, and you get your money back. Whereas if you're going for damages, your problem is that, like, even if you can quantify that misrepresentations occurred, then you've got to try and quantify the damages. So I'll give you an example from the case I'm doing right now. The business that was sold was one with like quite a strong existing client base that demanded, used the business's services from time to time, and it used subcontractors to do most of the actual manufacturing work that the business did. So it was a business of a nature where most of the value was goodwill, and most of it resided in the relationships that the previous owner had with the clients and with the subcontractors. So it was a situation where a restraint of trade, was a really essential thing to have, because if the previous owner could just go along and continue to court those customers, continue to use those subcontractors, it would be pretty hard to argue that in effect anything of value was really parted with. Now, the previous owner did breach the restraint of trade shortly after sale. But the problem that we encountered is that the breach was not particularly significant. The one that we were aware of, the value inherent in it was not great. So you've got a situation where the turnover's way down. There's been a breach of the restraint of trade and that it's of some value, but nothing like the diminution in turnover. And you're going, we can sue on the back of this breach of restraint, but, we've got no certainty in doing so what kind of damages we can prove and what kind of money we could therefore recover, and therefore whether or not it would be worthwhile to sue and face the risk of litigation.
What is quite good, and we actually had this done to us, my business partner and I, with a business that we own. We bought a competing business, and we knew that it was, we were pushing it in terms of the restraint, although it was arguably unenforceable due to its length. And we also knew, because of the particular circumstances we were involved with at the time, we had to act and secure this asset and then deal with the restraint issue later. But the other side were reasonably capable in terms of how they handled it by threatening an injunction against us. And by just the mere threat of this injunction and the fact that on the face of it, it was very likely that they would at least get an interim injunction pending the outcome of the formal hearing, was sufficient deterrence for us to have to settle. Now, it wasn't a lot of money, but it wasn't insignificant either, and it was still worth doing, to this day. But that can be quite a good tactic as well for someone who has had a restraint breached against them that's causing loss. Now, if there are much bigger losses and it's the early part of the restraint, that is, again, a very, very good tactic, because not only can you potentially get that injunction, particularly if it's, say, a hospital business, which our one was, they can't actually trade pending the outcome to the formal hearing, but also that can obviously set you up nicely for the formal hearing in terms of determining the losses.
An injunction is often a good first step. With the present case, it's something that we've been considering doing and may well do. But the thing that makes it more difficult than, like, as you say, you're right, when it's sort of a physical business like a restaurant, and it's very easy to ascertain where the trading's occurring, and it's very easy to shut that down. That's one thing. But when you're talking about, say, a services firm that provides work, but it does work for specific customers, you don't know who those customers are even. Then it's like, it is good in as much as people will think twice about breaching an injunction obviously because of contempt. It's much more serious to do that than to breach a contract. So
Yes.
and you get into court a lot quicker too, which is
Yes.
also another advantage.
What do you think? Do you think that decision has any implications for, say, sale and purchase of businesses where more higher level or sophisticated businesses, which have some complexity in terms of valuation and valuations perhaps being obtained, and the provision of those valuations by the vendor or the vendor's lawyer or a broker? Do you think that the decision has any implications? I'm trying to rack my brain over it. Say, for example, and again, I'm just sort of spitballing out loud here, but say, for example, a vendor and a purchaser have negotiated in an industry where the multiple was, say, 2.5 to 3 times, for example, hospitality, and then the vendor went and commissioned. I don't know why they would do this if they're in that situation, but stranger things have happened. Trust me. They went along and got a firm to value that business, and it turned out that valuation, which was in the position of the vendor, the lawyer, and the broker, and that came out to be substantially less than this multiple because of whatever modeling or assumptions they worked from. Using the sort of the corollary facts of this earthquake insurance claim case. And I know it's different, but in some ways it's not conceptually. If the purchaser through the traps found out later that this happened, would there be issues for any of those 3 parties, and why?
Yeah, I mean, I think conceivably there could be. So, like, evaluation, that's kind of in that same realm of something that would ordinarily be considered an opinion. But I guess if you possess this thing and you provide some other metric to determine the price, and you have this in your back pocket, like, it does seem to be quite analogous on its face to what happened in this case.
I suppose that there would be a distinction on the basis that there was a contract between the insured and the insurer, and it set out how the claim was to be satisfied or measured, the metric, and then there was the one valuation put forward as being the valuation put forward as the costing, so to speak, by the third party company, and as the only valuation put forward when that wasn't true. So it's brought all a lot closer to home. I don't think, in the example I gave, I don't think there would be any obligation incumbent on the parties to bring something which had never been discussed or mentioned forward, because otherwise, how do commercial parties transact and allocate risk, and what then is the value of having the purchaser having carried out DD if they could find anything? Because what's the difference between that valuation and just someone else's opinion? It starts to unravel and become absurd.
Well, yeah, and I mean, I think valuations, like, you're talking about something where, you go to a range of valuers, you get a range of opinions. It's not an exact science. And so it's much more in the realm of opinion than maybe the interpretation of a clause is. Though, of course, there was this insurance policy contract, and there were misrepresentations about it, but they were misrepresentations made in pursuit of entering into a different contract, which was a settlement agreement. So, I think you could have misrepresentations made without a pre-existing contractual framework between the parties. The thing that I think, really thinking about what the effects of this will be, I think they could be more proactive than reactive. Like,
what do you mean?
I could imagine a lot of commercial counterparties and their solicitors now kind of putting riders in emails and negotiations, like general riders to the effect that, the views and the things expressed herein are opinions, and should not be relied on, and we encourage you to get independent advice, notwithstanding that the Dodds actually had independent advice. But, certainly that was a big part of the court analysis, was that these things were kind of presented very much as fact, rather than, this is our view. If it had been, this is our view, they would have been okay. And that to me is a little odd. Like, the Court of Appeal said that, the English cases talked about how often when it comes to these sort of situations, like law and fact kind of blur into each other. And I think that's true when you're talking about things like you've got a contract and a clause that just unambiguously says X, and you say there's no such clause, or you say that it says something completely different to what it says. Like, that's a factual statement about, a legal instrument. And it's different. It's sort of, you can see there's a grey between that and things where, it's unambiguously a legal statement about what the law.
Here's a question for you. What would the court have done if there was no report in existence whatsoever, and it was just a question of them say they interpreted the cost, or they had a division of their company to interpret the cost themselves? Would they still have been guilty of misrepresentation?
Yeah, that's a very good question. I mean, like,
because that would be a good way, like a control experiment in a science context, to control whether or not that opinion was actually sufficient in and of itself for a finding of misrepresentation to be proved.
Mm-hmm.
I can't help but thinking it was really the fact that they had these other reports and they essentially cut 20% off it because it didn't suit them, and then gave that. I think that's what really sunk these guys, I reckon.
So you think if that was internal advice that they might have got away with it?
I just think it would be harder for the court to say. I just think, viewed globally, the fact that they got provided the report, and then they only gave, let's speak in really lay, simple terms about it. They only provided part of it, and it suited them to the tune of 200,000. And then they represented that based on that was their appreciation or their assessment of the cost. But it actually wasn't. But what if they had done it themselves and just said, "Oh, actually, in our professional opinion, we're not taking into account these contingencies because they are notional," which is a load of rubbish anyway, because the whole thing is notional, the whole exercise is notional. But if they just said, "This is our view, and that's what we're sticking by," because in the decision it even said that they even cross-examined Mr. and Mrs. Dodds, and they both said that they don't actually know what they would have done. Had they known. But the court was right to point out there that that's irrelevant because they were robbed of the chance to either negotiate a better settlement or seek an order from the court, which would actually give them some amount of real-time redress. But yeah, I just think, I don't know the answer to my question. I'm not trying to sound like some sort of smart, wise guy, but I just wonder if that report, that smoking gun, so to speak, didn't get discovered. Well, I think we do know the answer, because if these people hadn't seen the decision in the other case and then requested the disclosure under the Privacy Act, there would have been no smoking gun, so to speak, to show that they actually misled them.
Yeah, I suppose not. I mean, I guess there are conceivably other ways like that an internal thing could leak, or could have become relevant in other litigation, but I think it'd be a lot less likely.
But would it have been sufficient? Because, if you're the Dodds, bless them, and you get this document and you realize you've been had your pants pulled down to the tune of 200,000 big ones, and you saw this other case going ahead, I think you'd have a go, wouldn't you?
Yeah, well, that's where I kind of feel a sense of puzzlement about this case, is that, the fact that they had this report and then they effectively redacted it to suit themselves. I agree. That's kind of the terrible thing that's happened here, that everybody just intuitively knows is bad. And, you know, that's a factual thing. That's very much in the line of, you know, I'm just going to pretend something doesn't exist when it does. Like, and so I can't see why the court couldn't have just stopped there.
Did you get the impression as well that it was kind of somewhat like, it was quite far down through the judgment, and it was kind of almost tacked on, and it didn't really get explored that much, did it? And then they sort of decided that was...
Well, and that's kind of where, like, they've not exact. I saw an opinion on one legal website saying that this is going to clarify the law for people, and I didn't really agree, because they mention this whole thing about statements of law, and how the UK no longer says that they can't be misrepresentations, and then they say, you know, but we don't need to go there today, and then they kind of do. So, you know, I think you'd have to conclude that there could be future cases where, you know, misrepresentation is found exclusively on statements of law, but equally, I suspect it'll take a few more cases that are quite sympathetic before that position sort of becomes...
So what can you explain what the UK position is, just a bit more, just to explain to the people watching exactly the significance of that and what the court's done here?
Well, I mean, you know, I would be lying if I said that I'm an expert on the UK position.
Yeah, but just brief. Yeah, the gist of it.
Yeah, the gist of it is really just that if you make statements of law, those can be misrepresentations for the purposes of inducing someone to enter into a contract. So it kind of goes a little bit further than, you know, saying like say there's a clause in a contract and you say to the counterparty, you know, that clause means something completely different to what it means, and they rely on that. That can be just as much a basis for misrepresentation as if you'd said something factual that wasn't true, even though what a provision in a contract means is contentious usually, and a matter of opinion, and you know there is no hard fact on it. But I'll tell you the thing that with all of this that I just find somewhat flummoxing, like the Fair Trading Act. You know, you can see how in a consumer context, like with the Dodds, it's important to have that extra protection, because people do rely on statements about their legal rights provided to them by big companies when they're not sophisticated people. But the FTA can be contracted out of for commercial counterparties. And, you know, you can have an entire agreement clause and you can get out of all that. So, you know, it makes you sort of, you have to ask, like, what advantage is there for commercial counterparties represented by lawyers to be able to rely on the legal statements made by the other side in a negotiation? It would seem to me to make the whole art of negotiating much more fraught than it needs to be.
And why is that? Why do you think that could be the case?
Well, it's not uncommon, at least in sort of my day-to-day experience, that if you want to get you know, something across the line that you're negotiating, and like you want to win on certain points, like your first best sort of course to take is to present those things to the other side quite casually, like, this is just the way it is, guys. You know, like, they're not that important to you, and like they're obviously how you think they are. If I had to negotiate an agreement and I had to say, this is what we think should be the case for XYZ, but please be advised that this is just an opinion. These matters are contentious. You know, a court may conclude differently. You know, I can't see that would be. I think it would make it somewhat harder to.
I agree.
I mean, like it's a balance thing. It's going to be the same for the other side.
Yeah.
But it definitely is a big departure from kind of the way we all sort of intuitively assume it works. You know, you get your advice, I get mine. We both argue about it. You know, it's odd.
I don't know what I think about, and I haven't turned my mind to it a lot, but I just think it's I see what they're trying to do, because they're trying to protect the situation where these people have been told by the insurance company this is the effect of the clause, and that's why they're trying to argue that duty of good faith as well. And they don't want the system, so to speak, to be that insurance companies can sort of run rampant or run amok, so to speak, by being able to go, oh, this means this, you'll be fine, don't worry about it. Then it turns out, you weren't fine at all. But like you said, if there's two commercial counterparties and they're both represented by commercial lawyers who you'd hope know what they're doing, to have that advice and to enter into the contract, it almost, you could argue, and I'm not saying I believe this, but just playing devil's advocate, you could argue that then the contract, what's it called? Contra proferentum, the Latin term in terms of about interpreting the contractual terms in their plain or ordinary, commonly widely accepted meaning, loses some of its significance if you can later say, well, there's a representation that came along with that term, which I relied on to say, actually, it's fine because that won't be enforced that way, or that doesn't mean this. It sort of creates it brings to life a whole new body of possibilities, doesn't it, in terms of contractual terms?
It does. And it's also somewhat, until today, I would have been startled if a counterparty in a legal dispute suggested to me that they were relying on my advice. Like, I'd be like, what are you talking about? I haven't advised you. But it would seem that door's somewhat open too.
That's a little bit scary, isn't it? I was never a dull moment with the law, everybody, and Mike and I are here to really brighten up your evening and get you off Netflix and give you some of these fantastic insights, which I'm sure it will put you to sleep with. But we hope to, I wouldn't say we entertain, but we hope to be somewhat informative and, give people kind of a rare access to, or really access to some discussion around what's going on with these types of decisions, and keep it dynamic and fluid. And we've enjoyed presenting to everyone tonight, and we look forward to seeing you next week. I'm on picking the topic next week, Mike, so I'll see what we can do with that. But thanks again for coming on, and we'll see you up in Auckland on Friday.
Yeah, sounds good, Shane. Thank you very much for doing this again.
Cheers, buddy. Bye.